We go to Houston, Texas for a hearing. 38-year-old Rolando Areola has been charged with criminal trespass. A week earlier, Areola was arrested for trespassing at a gas station convenience store. He'd previously been ordered by the court multiple times to stay away from the business. Today, Areola, who's being held in jail on a $5,000 bond, appears before Judge David Fleischer to discuss next steps in the case.
You have terrorized the people at the Chevron for the last 3 years. I've told you time after time after time not to go back to the Chevron. Yet you persist and you go back. I've ordered you not to go back repeatedly. Yet the minute you get out, you go back to the property over and over. So what can I do to ensure that you're not gonna go back? If you were in my shoes, what would you do?
You've asked me.
Yes.
Now, once I've been to the
I've
court
asked
order.
you, I've ordered, I've prayed, I've done smoke signals.
These people know who I am. They allow me to go to the back of the store.
If you want, I will call them right now to see if you're allowed to go back.
I'm telling you this. I will not go back to that store.
And you done told me that before 18 times. Get the phone number.
At Judge Fleischer's request, State's Attorney John Kim speaks with the store owners and reports back to the courtroom.
The complainant stated that the defendant has previously come in with a stick and another time with a crowbar. The complainant is fearful for his safety. All 4 employees stated that they do not want the defendant at the gas station.
That is from the mouth of the people that work at that gas station.
This is the first time that I've heard that. It's troubling. I'm troubled from what I've just heard right now.
Don't go back. They're scared of you, Mr. Areola. They are scared.
Believe me, yes. Now that this statement was made, believe me. Okay, I have a family to take care of, and my time is being taken away from me being able to provide for my family. I promise you today, right now, that I will not go back to that. I'm telling you right now, because this is troubling. I promise you, this court, I will not go back to that store.
After 2 more days in jail, Areola is brought back before Judge Fleischer to enter his plea. But first, the judge wants to make another call to the store owner.
We spoke previously about Rolando Areola. Is he allowed into that Chevron?
No, sir. I've given him multiple chances, and it's better to keep him off the property.
He's telling you he don't want you there. This is Judge Fleischer, and I'm trying everything in our power to make sure that Mr. Areola doesn't go back. And
Yes,
we are going to release him, but I want you to let me know if he goes back, okay? Don't go back. You understand?
Areola pleads guilty, and the judge elects to give him a shot at probation.
Are you going to be able to complete this?
Okay. I will.
Okay? We shall see. I really hope so. If you go back, I swear I'm going to explode from anger. Do you understand, Mr. Areola? Okay? Good luck.
The judge sentenced Areola to 180 days in jail, which was suspended in lieu of 2 years probation. Areola must also take a class called Thinking for a Change in order to learn how to make better decisions. Since his release, he has not returned to the property. But 2 months later, Areola violated his probation when he was arrested in another county for assaulting a peace officer. That case is pending.
We now head to Stillwater, Oklahoma, for a lesser-known aspect of the legal system that we rarely touch here on Court Cam. the potentially dangerous business of bail bonds.
Seated behind the desk of signature bail bonds is owner 41-year-old Chastity Carey. A week earlier, she was hired by this man, Brandon Williams. Carey paid his $35,000 bond so he could be released while waiting to return to court to face charges of second-degree burglary and possession of marijuana. The third person in the office is Chastity Carey's 19-year-old son and the butt of Williams' jokes.
You got out of jail? No, you're a boy, ain't you? Just got out of jail. Ouch. I ain't gonna lie, bro. I hit on your mom nonstop. Well, no, I don't.
But this is no laughing matter. Williams is unaware that Carey and her son are planning to revoke his bond and take him into custody after they learned he was planning on leaving the state for a trip to Florida to attend his mother's funeral.
What? Turn around. What do you mean? Turn around. What's going on here?
I'm going to sit and talk to you in cups. We're going to go chat. Turn around.
Well, I'm not getting no cups.
Yeah, actually you are.
For what?
Speedy on the whatever, you can turn around.
Williams quickly realizes Carey isn't playing around.
Turn around.
Open the door.
Hey, turn around.
Don't put your hands on me.
Turn around, put your hands behind your back.
Don't put your hands
Turn
on
around
me.
and put your hands behind your back.
Why? What are you doing this to me for? Why are you doing it?
Ow! Hands behind your
What are you doing this to me for, man? Wow.
Holy
Mom, you just shot him.
I did. Call PD.
Mom, what is
911. 911.
Mom, you?
After Williams is blocked from leaving through the door,
Why are you doing it? Ow!
he tries climbing out a window just off camera and onto a balcony below. That's when Carey grabs a loaded handgun from her desk and fires a single shot, striking Williams in the lower back.
Mom, you just shot him.
I did. Call PD.
Mom, what is
911. 911.
Mom, you?
Police and paramedics arrive shortly after, but Williams is pronounced dead at the scene. In the police interviews that followed, Carey claimed she was acting in self-defense and that Williams had attempted to take the gun away from her right before she pulled the trigger. The video, however, appeared to tell a different story. Carey was later arrested and charged with first-degree murder. Cameras were not allowed in the courtroom during the 4-day murder trial, but the surveillance video would be a key piece of evidence for both the prosecution and the defense. The state argued Carey was not acting in self-defense because the video showed Williams trying to get away from her when she shot him in the back. The defense, however, said, quote, "What's not on the video is the reasonable doubt." And what that means is to convict Carey of first-degree murder, jurors would need to believe that she deliberately intended to kill Williams. Ultimately, the jurors decided the state's case did not meet that burden of proof. Carey was found not guilty of first-degree murder. The victim's ex-wife has since filed a civil lawsuit against Carey. We go to Flint, Michigan for a hearing on a civil case. Judge Herman Marable Jr. presiding. The plaintiff is 43-year-old Kashante Short. She's filed a $10,000 lawsuit against Richard Jordan for intentional infliction of emotional distress, which she claims occurred when they went out on a date. This is not the plaintiff's first lawsuit. Short previously filed suits against AT&T and the Flint Police Department. Both suits were dismissed.
I read your complaint again, and what is it, intentional infliction of emotional distress?
Yes, it is.
That's not something that's really justiciable in district court.
The judge is explaining that the plaintiff's suit for intentional infliction of emotional distress belongs in a different court.
So you said it's not permissible in district court, it has to be taken to circuit court?
That's an equitable action, yes.
I'm sorry, I gotta go back in because I can't hear you.
While Short finds a quiet location, the judge checks in with Jordan.
Mr. Jordan, let me just ask you this. Are you planning to represent yourself on this?
To be honest with you, sir, I thought this was just going to be thrown out. We had a date, one date, and nothing else after that. And now I'm being sued for $10,000. But I think it's a waste of your time.
The problem is this. If you think it should be dismissed, you can file a motion to ask for that.
If that's the process I have to take, then that's what I'll do.
There was also a perjury on there as well.
You heard right. In addition to emotional distress, Short is also alleging that Jordan committed perjury in a written response he submitted to the court.
He sent a letter, and then that letter, he lied. And then that's what brought forth the perjury response.
No. First of all, do you understand what perjury is?
Yes, I understand perjury is a lie. I know what perjury means.
Perjury is a statement, a false statement made under oath.
He was lying.
You don't understand. It's a false statement made under oath. Under oath.
That stated a lie.
When did he testify to something that he lied about? It's a false statement made under oath.
Are we done here?
No, you don't understand, ma'am. You don't understand.
Are we done here? Are we done here?
I don't think you understand what perjury is. It's a false statement made under oath.
Are we done here? Are we done here?
Please
do not insult my intelligence.
I said no.
Do not do that. Do not do that. Do not insult my intelligence as if I do not understand what the word perjury means.
Listen. I'm not going to sit here and go back and forth with you. I will repeat to you what I said.
I'm not either.
I said that intentional. You need to be quiet while I'm talking. You need to be quiet. Can you mute her, please?
Because perjury is a criminal offense.
The plaintiff is muted while the judge figures out what his final ruling will be.
Ma'am, this is what I'm doing. I am ordering that this go to 7th Circuit Court because intentional infliction of emotional distress is a circuit court matter outside the jurisdiction of district court. If you want to appeal my ruling, you got 21 days to do it.
Yep, I do.
You got 21 days to appeal it to the circuit court.
The suit is now with the circuit court, and the results are pending. Jordan has not been charged with perjury.
Thank you both.
Next, we're in Ann Arbor, Michigan for a sentencing hearing. 43-year-old Andrew Lewis has pled guilty to 4th-degree criminal sexual conduct. 3 years earlier, 40-year-old Christy Kenyon was invited out for drinks by her hairdresser, who brought along her husband, the defendant. Later that night, back at Lewis's home, Christy says she became lightheaded after eating a taco that he'd served her. She told police that the next thing she remembers is waking up naked and being sexually assaulted by Lewis. Christy reported the incident, and Lewis was arrested. Although she claims that Lewis's wife was aware of the incident, she was never charged. In a deal agreed to by the defense and prosecution, who'd gotten the approval of the victim, Lewis pled guilty to 4th-degree criminal sexual conduct and now faces a sentence ranging anywhere from probation to 11 months in prison.
Number 35, People versus Andrew Lewis.
Today he appears virtually before Judge Patrick Conlon, who will be handing down his sentence. Also on the call is the prosecutor, Christina Hines, along with the victim, who appears openly in court to face down the man who attacked her.
It has been over 3 years since the incident occurred that would forever alter my life. You and your wife invited me to a bonfire. You drugged the beer, you handed me towards the end of the night, and you drugged the taco meat. You carried my body from the living room to your bed, so insanely disgusting. You proceeded to remove my clothes and rape me. When I came to, I was beyond horrified and so confused as to what was happening. I could not move. I was paralyzed from the neck down by the drug that you used. I could not speak or scream. I lay there helpless as you raped me and did nothing. And you actually had the audacity to say to me, just keep still and it will be over soon.
That's defense attorney Ellen Michaels on her cell phone during the victim's statement.
You did this to a mom, to an innocent family. Do you understand that? You should be locked up and throw away the key. You are indeed a rapist. Your wife is your accomplice. I did nothing wrong and nothing to deserve this. Andrew Lewis, I came forward to ensure that you never do this to anyone ever again.
When she's finished, defense attorney Michaels makes a statement.
I'd like to speak to a minute about, some of the things you heard today. And Andrew's wife wasn't charged. If there was evidence that she had done anything wrong, she would have been charged. Moreover, there were tox screens taken of the complainant in this case, and there were no drugs in her system. And most drugs that give the kind of feeling that she described would have been in her system in the very short time frame of which she went to the hospital. There's been no evidence at all that that was the case, but there was evidence that she voluntarily did drink quite a bit of alcohol. And that's also part of what was going on here, is that all the parties were drinking alcohol and engaging in adult activities.
Judge Conlon's ready to render his sentence, but first he has a few words for the defense.
Ms. Michaels, I'm a little troubled by your speech there to point out how Ms. Kenyon might have been culpable at this stage of the game is perhaps not your wisest course in the future. Additionally, anytime a victim is making a statement, if you're ever in my court again and you pull out your telephone to do something with it, I'm going to stop the proceedings at that time because you did it twice. And I don't know if you're aware that your camera was on, but we all saw that. So utterly inappropriate.
The judge sentences Lewis to 5 years probation with several conditions. He has to register as a sex offender, undergo therapy, and he's prohibited from having any contact with the victim. We're in Ann Arbor, Michigan for a motion hearing. 39-year-old Michael Young, who pled guilty to failure to stop causing serious impairment, has been sentenced to 40 days in jail and 18 months probation. 3.5 years earlier, according to police, Young drove his truck off the road through a ditch and into a car that was parked in a driveway. Inside the car was 76-year-old Patricia Vital. She'd been visiting one of her daughters when the accident occurred. Young called a friend for a ride and fled the scene before police arrived. Patricia was taken to a nearby hospital, but died from her injuries the next day. With the help of eyewitness accounts, police identified Young as the driver and he was arrested. One witness claimed to have smelled alcohol in his breath, but Young declined to speak to police. And since too much time had passed since the accident, his blood was never tested for alcohol. Young was originally charged with failure to stop when at fault resulting in death and failure to stop causing serious impairment. But the first charge was dropped when he agreed to plead guilty to the second. Today, Young appears before Judge Patrick Conlon, having only served half of his 40 days in jail. But because he's scheduled for shoulder, neck, and leg surgeries, which could require a lengthy recovery time, Young is asking the court to adjust his sentence.
You're asking for early discharge. You're still kind of on the hook to serve 20 days in jail. So one possibility may be that if we were to waive this requirement that you serve the 20 days in jail, I would actually extend your probation and you would be on a scram and a GPS tether.
But the judge is troubled by reports from the victim's family that since the accident, Young has been spotted at the local bar while on probation.
Can I comment on that? Sure. There's a restaurant. It's the only one. I don't know if you've ever been to Bridgewater. It's a tiny little town with.
I do understand that, but just remember, sir, we're here today because of the death of a family.
I understand. It's the only place around to go to lunch. There's nothing to do with drinking, and I understand. I mean, I feel for everybody here, and I don't know where else to go with.
You're asking for early discharge from probation. I'm willing to extend your probation and waive one of the requirements of probation that you serve another 20 days in jail.
The prosecutor, Jessica Blanche, is not on board with this solution.
But there are victims who have lost a family member in this
For
case.
sure.
They were under the impression he was sentenced to a particular sentence. He was to serve this amount of time. For them, there's this closure here, and now we're saying, well, let's be accommodating. He's going to the tavern, I get it. Oh, well, there's not enough places to be right. Well, you can get takeout. I mean, this is a serious offense where someone lost their life.
Like, you're 100% right, but is him serving 20 days in jail better guarantee that he's not going to hurt anyone else than extending his probation further with conditions to show that he's sober?
Can I say?
Not really, sir. After I hear from the victims, I'm either going to give you a choice or not.
Before Judge Conlon makes his ruling, Patricia's daughters address the court.
He got sentenced to 40 days. 40 days. I've lived every day of my life being forced to relive that night because he killed my mother in my front yard in front of my children. He didn't even stay until help arrived. He chose to run away. It feels like an insult to my mother's life and to my family.
I agree with my sister that 40 days, it is an insult. Yes, I know she was 76 years old and she was older, but she had a lot of life left to live. The sentence, in my opinion, was so lenient to begin with, and to be discharged early, it's just insulting.
After hearing their statements, the judge makes his decision.
In light of what the victims have brought to me, I'm not going to make any changes to your probation condition, and I'm not going to grant you early discharge. But I'm going to deny the motion.
Young remains on probation and still must serve the remaining 20 days of his jail sentence. Next, we're in Atlanta, Georgia, for a protection order hearing. 53-year-old Rhonda Love has requested a TPO against Rietta Walker. Love claims that Walker has harassed her online and showed up at her house demanding money. Their connection? Walker has been having an affair with Love's husband of 7 years. Today, both parties appear remotely before Judge Alex Manning.
Miss Love, tell me what Miss Walker did to you, specifically what she did to you, please.
She showed up at my house 3 times, once with a man and a gun in her car. My husband came to the porch and said, call the police, she got a gun in the car.
Tell me what happened, why she came over there.
Her and my husband know each other.
Had an affair.
Exactly, and it has been going on for some time. She has been calling me like the first of every month saying that he owes her money. She started talking like, this is me, tell that call me or something she said. But I don't want to get between her and his relationship. I've been known about...
Are you okay with the affair?
I'm okay with it. I tried not to break them up because I wanted him to go there, but he wouldn't leave. He's still here.
Oh, so you want him to leave you and go be with her?
Yeah.
Well, Miss Walker, let him come on over and live. What do you do? You don't want him that bad either, right, Miss Walker?
I don't want him there. There's too much drama and a lot of lies. I don't want him. I'm okay. I don't have a problem with her either.
But look at that, Miss Walker. She don't even want him. You can't even give him away. You don't want him. She don't want him.
The judge seems baffled by the situation, but things only get stranger as Love explains how the altercations nearly became violent.
She started to insult me. Then she left after I called the police. And then when she came back again, she came back with a butcher knife. She had that knife out in her hand. She is running around here with a butcher knife in my yard, slapping on my car. I really had to send a warning shot at her in order for
Wait, you fired a shot at me?
Yeah, I did.
Okay, wait a minute. But you shot at her. You fired a...
I shot a warning shot into the ground.
Oh my God.
The two women continue arguing until Judge Manning learns that the man they're fighting over has 13 children from 12 different women.
All right. He has 12 children. 12 children by 12 different women.
13 by 12.
13 kids, 12 different women.
And listen, I love children. These women are all fine with me. I'm fine with them. And maybe he's whorish. Maybe that's his thing. But at the same time, he's good to me. It's not about what he and I got going on or how many children we have. You don't never go to another woman's house about no man. This is not what women do, especially not business women. Business women do not clown like that.
Before making a ruling, the judge wants a little more information from Love.
So you knew he was a cheater when you married him?
Exactly, and I agree. Because that's our choice. I knew he was a whorish man. I knew he was. But that has nothing to do with how I feel about him or how he makes me feel.
I don't know. He would make me angry. Most people he would make angry. But here's the deal, man. I mean, you can't go out firing weapons, even if she is out there kicking you, kicking your car or doing whatever. Miss Walker?
Yes, ma'am.
Your mama, she must want better for you.
Yes, ma'am, and I am doing better. I'm doing a lot better.
This ain't some sister wives things. I don't know what y'all got going on, but there's a whole bunch of drama. Here's what I'm going to do, though. In 30 days, ma'am, this is going to be over. Ms. Walker, don't go back over there. This is going to expire on October the 23rd.
And I'm asking for my PTO. And I'm asking.
I'm granting it for 30 days, Miss Love. Miss Walker, God help you. You live in the same neighborhood. So if you got to pass her house, find another way out.
Okay.
After issuing the 30-day protection order, Judge Manning has a final comment for the plaintiff.
Miss Love, put your gun away. Because once that bullet leaves the end of that barrel, there ain't nothing you can do to control it. There is no such thing as a warning shot. You understand me?
Yes.
Next, we head to Eureka, Kansas for a preliminary hearing. 33-year-old Bailey Cargile has been charged with aggravated battery on a law enforcement officer, fleeing an officer, possession of opiates, driving under the influence, and other charges. A month earlier, Cargile was driving with her boyfriend when police say they attempted to pull her over for driving recklessly. Police say that's when Cargile slammed on her brakes, causing the officer to rear-end her vehicle. Then officers say she got out of the car and fled the scene. But after a brief foot chase, Cargile was apprehended. Inside the vehicle, police say they found cocaine and methamphetamine. Cargile and her boyfriend, 25-year-old Owen Solomon, were both arrested. Solomon, who was hit with 4 drug-related charges, was released on $12,500 bond, while Cargile was held on a $45,000 bond. Today, Cargile appears from the county jail before Judge Phyllis Webster to discuss next steps in the case. Solomon is also on the call for his case. The county prosecutor is Jill Gillette. Cargile's represented by attorney Richard Paul.
Mr. Paul, you said you wanted to be heard on bond?
Yes, Your Honor. Right now, she's being held on a $45,000 bond. We would ask for a $25,000 cash or surety bond. Judge, also, there's a no contact order with her boyfriend. They've been together 5 years, and I would ask that the no contact order be lifted as well.
Ms. Gillette, what do you have to say about this request?
Judge, she had 4 failures to appear on her record and has run twice. So I think 40,000 cash surety is appropriate for the charges.
Judge Webster has heard enough and is ready to make a ruling.
I appreciate your efforts on behalf of your client, counsel, but the modification request is denied at this time.
Including the no contact order, Judge?
Yes.
Okay, thank you.
Before Cargyle returns to jail, she makes a subtle gesture towards the camera.
Who are you telling you love?
And the judge takes notice.
Did she just file late? The court's order of no contact, sit back down.
It appears Cargyle mouthed, "I love you," twice. Perhaps in the direction of her boyfriend.
Who are you just mouthing "I love you" to?
No, I was just saying that I'm about ready to go.
No.
Like, I'm about done.
Ma'am, I can replay the tape. You
Okay.
said, "I love you." Who are you speaking to?
I love my lawyer.
Who do you love? Who did you?
My lawyer, like for having my back today.
No, come on.
Like I like him.
Okay, so you love your attorney, you like
yes,
your attorney, and you are mouthing to your attorney, to Mr. Paul, "I love you."
I was actually saying it to the guard as I got up.
You were saying it towards the camera as you got up.
I was like,
okay, stop, Mr. Lennon. Is the co-defendant on here?
Judge, he's on here.
All right. Is Owen Solomon your boyfriend of 5 years?
Yes, Your Honor, he is.
And you didn't know he was on here?
I can't see. There's a lot of different people up on the screen, and you were the big one.
Okay.
I was literally talking to the CO.
No, I don't buy that. You were looking at the screen. Your mouthing was very clear. See, this is why I can't trust you to have a bond modification. You just burnt some serious bridges on credibility with the court, because you just showed me you don't have respect for the court. You don't have respect for your attorney, even though you claim he's the one you love. In any event, go ahead and leave. Go with the jail now. And just
thank you, Your Honor.
All right.
Cargyle was later released on her $45,000 bond and has yet to enter a plea. If found guilty, she's facing up to 33 years in prison. As for Solomon, he was charged with possession of narcotics, possession with intent to use drug paraphernalia, and other drug-related charges. If found guilty, he's facing up to 11.5 years in prison. Both Cargyle and Solomon's cases are pending. We're in the Ann Arbor, Michigan virtual courtroom of Judge Cedric Simpson for a sentencing hearing. 41-year-old Natasha Mitchell has pled guilty to operating a vehicle while intoxicated. A year earlier, police found Mitchell outside a pizza parlor in the driver's seat of her car, along with a bottle of tequila. Her blood alcohol level was 0.119, well above the legal limit of 0.08. She was arrested and released on a personal recognizance bond. Mitchell is banned from drinking alcohol while out on bond and has been required to use a SoberLink portable breathalyzer for the past year. And while she's consistently had negative test results, she's recently missed some tests completely. So the probation department is requesting she be given jail time and upgraded to an ankle bracelet.
Okay, where are we on this one?
There was a request for 4 days in jail to report to the Washington County Jail today at 6 p.m. to get a scram tether placed on her.
This all seems to take Mitchell by surprise.
Please don't put me on a tether. It's embarrassing enough have to blow when I do. I've been blowing for probably, a year now. I have had some times where I've missed because of falling asleep or just simply forgetting. Lord have mercy. Please give me some leniency.
Miss Mitchell?
Yes.
How long have we been dealing with each other?
I don't know. It's been a long time, but I haven't seen you in a long time. It's been years since I've seen you.
Mitchell and Judge Simpson have history. She's appeared in his courtroom several times before.
Miss Mitchell, if it's been all that long, why do you think I remember you?
Because you always was saying how my face was looking mean or how I always look mean, but I smile now. I don't.
You always would appear before me with, you had a scowl.
I had an attitude. I had a very bad attitude.
Yes, you did. I'm glad you finally admit that. I kept telling you that.
That's the old me.
Let's see if we can get you through this, Miss Mitchell, okay?
With the reminiscing over, Judge Simpson turns his attention to the question at hand, whether or not to punish Mitchell for her mistests.
So here's what I'm going to do, Miss Mitchell. I'm going to place you on 24 months probation. I'm going to continue on the sober line.
I appreciate it.
But you cannot miss any tests.
I will not miss any tests.
I will not have her report to jail at this time.
I won't let you down. I appreciate you.
Miss Polera or Elin, if she even begins to mess up, come find me personally, because I'm going to get in my truck and we're going to go get her.
I will make note of that.
And she does not want me just rolling up on her, because I will.
I sure don't. I sure don't.
Mitchell's serving her 2 years probation, but she avoided jail time and remains on her sober lane. Judge Simpson has not had to deploy his truck. Next, we head to Rochester Hills, Michigan for a sentencing. 53-year-old Jeffrey Ziegler has been convicted of assault with intent to do great bodily harm and possession of a firearm during a felony. 7 months earlier, 14-year-old high school student Brennan Walker missed his morning bus and decided to walk to school. But he got lost and didn't have his cell phone, so he knocked on Ziegler's front door looking for directions. Ziegler's wife, Dana, answered the door and asked, "Why are you trying to break into my house?" She then yelled, prompting Ziegler to hurry downstairs with a shotgun. As Brennan ran away, Ziegler fired in the boy's direction, but missed. Ziegler's wife frantically called 911.
What door is he at?
And police quickly arrived on the scene. Ziegler told authorities that he slipped and the gun went off by accident. But after viewing the security footage, the state filed charges. Ziegler, a retired firefighter, was initially charged with assault to commit murder, which, if convicted, carries a maximum sentence of life in prison. He pled not guilty and was released on $50,000 bond. The case went to trial, and after reviewing all the evidence, the jury found Ziegler guilty on the lesser charge of assault to commit bodily harm, as well as the firearm charge. Today at sentencing, his attorney asks Judge Wendy Potts for a sentence within the recommended guidelines of 2 years in prison. But the prosecutor, Kelly Collins, argues for a more severe punishment, emphasizing that this was not Ziegler's first time firing a weapon in public.
This court can't ignore that this is not an isolated incident for Mr. Ziegler. He has fired a weapon in an incident of road rage. I absolutely hold the position that Mr. Ziegler should serve not only the 2 years for the felony firearm charge, but additional incarceration for the assault with intent to do great bodily harm less than murder.
The next person to speak is Brennan's mother, Lisa Wright, who addresses the court with Brennan's stepdad, Stephen Wright, by her side.
I don't feel like he's remorseful. I don't feel like he's shown remorse. I feel like it's only because of the media he feels as though he has to. He said he's sorry. I don't think it's fair.
Before Judge Potts imposes sentence, the defendant delivers his own statement.
I'd like to apologize to the family for my actions on that morning, April 12th. I know it's wrong. After spending 35 days in jail, you do a lot of soul searching. I am full of remorse and regret, and I wish I could change something, but we can't go back in time.
When he was finished, the judge made a brief statement before handing down her sentence.
Shooting at a teenager leaving your premises has consequences. It is the sentence of the court. Count 1, assault with intent to commit great bodily harm, 2 to 10 years, Michigan Department of Corrections. Count 2, felony firearm, 2 years, credit 35 days. Count 1 is consecutive to count 2.
Judge Potts decides to go beyond the guidelines and sentences Ziegler to a minimum of 4 years in prison.
I don't object to the sentence going above the guidelines at this time.
Guidelines are advisory, and based on the circumstance of the case, the court feels they're appropriate.
Ziegler later appealed the sentence, but a second judge actually increased his assault sentence by 6 months. In total, Ziegler received a sentence of 30 months to 10 years for the assault charge, plus 2 years for the weapons charge. They'll be served consecutively. As for Brennan, he recently graduated from high school and is now attending college in Florida. Next, we go to bond court in Miami, Florida. Judge Mindy Glazer presiding. 36-year-old Adaya Baki has been charged with aggravated battery with a deadly weapon and armed burglary with assault. 2 days earlier, Baki went to a shipping store and asked for a refund for a damaged package. The manager refused, instead advising Baki to contact the seller. Baki was not happy and let loose on the manager. Surveillance cameras captured Baki punching the store manager, then following him behind the counter and hitting him several more times. Then Baki pulled a gun from his pocket.
I'm gonna blow your brains out.
As customers and a coworker fled the store, Baki pistol whipped the manager, then left the store with a warning.
I'm coming back.
Baki left behind his package, which was labeled with his name and address, so police were able to locate and arrest him the next day. Today, Baki and his attorney are before Judge Glazer to ask for his release on a reasonable bond until trial.
Mr. Delgado, the arrest affidavit alleges that this occurred behind the restricted area, I guess, of the store.
In Florida, committing an assault inside the employee-only area of a store can be considered burglary, since customers do not have permission to be there. But Baki's attorney argues his client was actually in a public area.
It's an open store. If you've ever been in one, they're all wide open. And you have to have intent to go into the restricted area to commit a crime. I mean, to refer to that as enclosed or restricted is completely ridiculous, and it's not consistent with reality. I would ask the court to find no PC on the burglary with the battery charge and give him a bond and let him post it.
Okay, state. If this is an area.
The judge, counsel's referencing a video. Does Your Honor want to see it?
Sure.
There's the cash register, the desk, and then the employee-only area that's behind the register. So it's the state's position that common sense dictates you can't go behind the counter of a business where the cash register is.
I'm not excusing this conduct, believe me, but there's nothing indicating to the public that you're not allowed to enter. Right? There's probable cause for an aggravated battery and a battery, but I don't think there's enough for armed burglary with an assault or battery.
Because the judge finds no probable cause for burglary, she releases Baki on that charge. Now the hearing turns to the aggravated battery charge and whether Judge Glazer will set bond or hold Bakke until trial.
Mr. Delgado, for the aggravated battery, I'm setting that bond to $20,000. It's plus house arrest with the GPS monitor.
5 days later, Bakke posted the bond and was released to house arrest. He's pled not guilty to the charges, and his trial is pending. Next, we're in Amarillo, Texas for an arraignment. 64-year-old Eddie Ray Gibbs has been charged with possession of drug paraphernalia. 2 days earlier, police responded to a criminal trespass call at a fast food restaurant. Gibbs was at the scene, and when police searched him, they discovered a glass pipe and small amounts of crack cocaine in his pants pocket. Today, he appears without a lawyer before Judge Laura Hamilton to enter a plea.
Hi, Mr. Gibbs. How are you today?
Hi, Judge.
How are you today?
I'm blessed and highly favored, man.
Well, isn't that wonderful? So here's the deal. You've got this one possession of drug paraphernalia from July 8th. How do you want to handle that?
If I may.
You what?
What my doggone pants?
What?
That's right. Gibbs is claiming the pants he was wearing, where the drug paraphernalia was found, do not belong to him.
They weren't my pants, so I don't even do drugs.
Gibbs makes his case to the judge.
My pants, they're all dirty, so I had to wear my roommate's pants.
So you put your roommate's pants on.
Yeah.
And your roommate's pants had stuff in the pockets.
Yes, I didn't check.
But so who was in control of that situation at that time?
I was.
I know. I'm so sorry, Mr. Gibbs.
I understand. It's so fine. It's all right.
You can plead not guilty, no contest, or guilty. You're welcome to plead.
Because I had them on. So.
I know. Well, but you can come in, if you want to come in and talk to the prosecutor to see if you can work out a different deal. If you are concerned about the conviction, you're not concerned about that?
I have to pay some accept whatever the consequences are, ma'am.
Didn't you tell me you're a preacher?
Well, I am trying to preach the word. Okay. It's called Divine Fellowship of Love.
Well, I don't want to do anything that's going to negatively affect your ability to do what you want to do that way.
Yes, ma'am.
So if you want to come in and talk to the prosecutor, maybe she would offer you deferred. You'd have to pay some money up front.
No, ma'am, Miss Plant, all I want to do is get it over with. Like I say, they wasn't my pants, so what? Okay. I accept what it is, and I'm ready to just move on and get my life right. My life is right. I'm doing God's work.
I guess from in my mind and in your mind, God knows. God knows.
He knows. So, he knows. Yes, ma'am.
Okay. So are you pleading guilty or no contest?
I'm pleading.
Despite Judge Hamilton's advice, Gibbs sticks with his plea.
I plead guilty.
Okay. Okay. Yes, I'm going to find you guilty, and I'm actually going to time serve you on this. So I'm going to give you the benefit of the doubt on that. I am going to adjust your fine to $219. Your court costs are $81. Your total's $300, and you are time served. Okay?
Yes, ma'am. And I'll be there at 2:00 today, tomorrow.
Nope, you're done.
Gibbs doesn't seem to understand that the judge has sentenced him to time served and that he's free to go after paying his $300 fine.
You don't even have to come in. Okay?
Well, amen. I love you.
Thank you. You have a good day. Thank you, Mr. Gibbs.
We head to Lawrenceville, Georgia for a contempt hearing. 48-year-old Sheila Holly has been charged with indirect criminal contempt of court. 7 days earlier, Holly was attending the retrial of her 22-year-old son, Austin Ford, who was charged with murdering his friend, 18-year-old Tory Lang. Ford pled not guilty, and on day 2 of his trial, Holly was brought before the court after a deputy observed her snapping a photo of the jury, which is a violation of court rules. The phone was confiscated, and Judge Deborah Fluker quickly reacted to the infraction.
I have taken a screenshot of the photo, and I will forward my screenshot to the court reporter for her to print and have it marked as Court's Exhibit 1. For the infraction, I am seizing Ms. Holly's cell phone, and Sheriff's Office will maintain possession of it until the conclusion of the trial. I'm also going to ask my staff to do a notice of hearing, scheduling a contempt hearing. Ms. Holly, you should consult with an attorney.
Today, Judge Fluker officially brings contempt charges against Holly, who faces 20 days in jail and up to a $1,000 fine. Deputy Rebecca Odom describes the incident.
As Deputy Hilbert was removing Mr. Ford, then he saw that Miss Sheila Holly had her cell phone. So he got her phone and he handed it to me. And when I looked at the phone, there was a picture in the small corner of the courtroom. That's when I advised the court.
After the phone and a picture of the jury are entered as evidence, Holly takes the stand and attempts to explain herself.
But did you see anything in the courtroom that, I guess, inspired you to take the picture?
I did. Throughout the trial, several of the jurors were asleep. My son is on trial, where they're trying to take the rest of his life for him. My anxiety was through the roof. I snapped the picture. After I snapped the picture, I was like, oh my goodness, this is so wrong. I'm not supposed to use the phone. And I was like, okay, I'm gonna delete it, immediately delete it. And I felt totally bad that, I even disrupted the court.
Next, it's Judge Fluker's turn to question the defendant.
Do you acknowledge hearing me repeatedly say multiple times a day throughout the proceedings the court's position regarding cell phones?
Yes, Your Honor.
And did you in fact hear me say that your phone needed to be completely powered off, not just on silent, while you were in court?
I heard you say that, yes, Your Honor.
And despite whatever anxiety you may have been feeling, you knew that it was wrong to take a picture of the jurors in court.
Yes, Your Honor.
After Holly returns to her seat, the judge makes her ruling.
I do find beyond a reasonable doubt that Sheila Holly is guilty of indirect criminal contempt of court. She intentionally disregarded a command of the court by having her cell phone powered on without prior permission of the court, and by improperly taking a picture of jurors seated in the jury box in the courtroom during court proceedings.
And with that, Judge Fluker imposes sentence.
I order that she shall purge herself of this contempt by serving 3 days in confinement at the Gwinnett County Detention Center. Ms. Holly will be immediately remanded to the custody of the Gwinnett County Sheriff's Office.
Holly served 3 days in jail, and upon release, her cell phone was returned and the contempt charge was removed from her record. As for Holly's son, Austin Ford, the jury deadlocked on his murder charge, but he was found guilty on 2 counts of theft and concealing the death of Tory Lang. He was sentenced to 10 years in prison plus 10 years probation. We're in Eureka, Kansas for a hearing. 48-year-old William Wayne Phillips has been charged with speeding and driving with a suspended license. 3 months earlier, Phillips was pulled over for driving 86 miles an hour in a 65 zone. He was also cited for his second driving with a suspended license offense. Today, Phillips appears without an attorney before Judge Phyllis Webster to discuss next steps in the case. But before the hearing even begins, Phillips seems to have irritated the judge.
Now, William Phillips, did the officer tell you not to smoke?
It's kind of hard to hear around here. I'm out of town on a construction site, and I'm the lead, so.
Judge Webster lets the cigarette slide and moves on to the charges.
Mr. Phillips, are you going to be hiring an attorney, sir? You could waive your right, though, and represent yourself, and we can either set this for trial or give you some time to talk to an attorney. What would you like to do?
If I need an attorney, I'm not going to get one from you guys. That's most definitely.
Okay, so you're going to hire an attorney?
Yes, ma'am.
All right. Let's put this on Monday.
Can it be scheduled after that? I won't be back in this area for the next, 2 or 3 months.
You want to try to do it before you leave? When are you leaving?
I'm already gone. That's the thing.
Already...
I'm in Independence, Kansas.
Well, that's not that far.
It is when I have to work.
All right, sir, I'm detecting a bit of an attitude, and I've had a bit of problem with you all day long. I suggest you kind of take a deep breath and try to get rid of the attitude, because then if you don't, you may cause me to have to get an attitude too. So
take that deep breath, do the same thing. You know what I mean?
Excuse me?
I said same. Do the same thing. Take that deep breath. Goose fraba.
Some of the others on the call seem amused by Phillips' comments, but the judge is not happy.
All right, Mr. Phillips, do you know what my title is?
I do, but that doesn't give you the right to belittle me or anybody else in your court.
I am finding your conduct contemptuous because you're interfering and disrespecting the process and the court. You are hereby fined for direct contempt of court, $100 cash.
That's fine.
You've complained that you can't be here when I tell you to, that it's inconvenient because you're maybe a couple hours away. Some of these people are in other states. So don't tell me.
That's not this case. That's not this case. This is my case, not their case.
Yes, it is. And that's $200 for contempt. You better get a clue who's in charge here. $200, Mr. Phillips, due in court Monday, or you can serve 3 days in jail. I have found you in direct contempt of court. You owe the court $200.
I don't owe you nothing. I owe the court and the state of Kansas. See, that's your problem. You're taking your own personality into your law, and that's not appropriate. Can we hurry and get this over with?
$500 cash for direct court, and I am ordering you to surrender yourself by 2:30 today to the Butler County District Court.
I cannot do that.
Well, then I'll send a sheriff out to get you.
I'm going to hire an attorney. I am going to get off this Zoom, and I want this sent to my email. And I demand this footage, because I'm going to take this and I'm going to appeal all of this. The whole time.
All right, I've given you my order. Disconnect him from the call. He better be here, or the sheriff will go out.
I will not be there.
Missy, disconnect him.
I was trying to reschedule it, so
All right, folks, let's move on.
Phillips failed to show up in court that day, and a bench warrant was issued for his arrest. After spending 6 days in jail, he was released on a $1,000 bond. His case is pending. Next, we go to Carlsbad, California for a sentencing. 42-year-old Julie Harper's been convicted of second-degree murder in the death of her husband, 39-year-old Jason Harper. 3.5 years earlier, Julie and Jason, a high school math teacher, were having an argument while their 3 young children were downstairs watching TV. According to Julie Harper, Jason charged at her, saying he was going to kill her. That's when Julie took out a loaded pistol and shot Jason in the side, killing him. She then covered Jason's body, and after disposing of the gun, took the children to her father's house 30 miles away. Later that evening, Julie Harper turned herself in, and the state charged her with murder. Just days before the shooting, Harper had filed for divorce and withdrawn $25,000 from the family bank account. She said that she shot Jason in self-defense, claiming he'd been abusive throughout their 10-year marriage. But investigators found no corroborating evidence of abuse, and aside from Harper's own testimony, none was presented at trial. When both sides came to rest, it took a jury 1 day to return with a verdict.
guilty. Today at sentencing, Harper waits for Judge Blaine Bowman to hand down her punishment. But first, a number of family members come forward to share victim impact statements, beginning with a written statement from Jason and Julie's 12-year-old son, read by prosecutor Keith Watanabe.
Julie Harper has caused much pain and misery to all the members of the Harper family. She murdered with no sense of the consequences, as leaving my siblings and I parentless. She had destroyed our lives and now will not accept the consequences. She did not realize that eventually she would go to jail, and now she is trying to weasel out of punishment.
Next, the prosecutor reads a statement from the Harper's 10-year-old daughter.
I blame Julie Harper most definitely for the fact that my father is dead. Also, I want to say that I no longer have a mother because she was so selfish and self-centered. She wasn't thinking of caring about anyone except herself. Because you killed our dad, you are no longer Mom. You are Julie. I will never call you Mom again for what you did, and I don't want anyone else referring to you as our mom. You made my brothers and me orphans. I beg the court to give her the full prison time she deserves.
Before the judge imposes sentence, the defendant makes her own statement.
A, B, C, D. Another behind closed doors. My husband was a different man behind closed doors. But he was a very different man to me. And it has been so hard to go through all of this for the last 3.5+ years after what I went through with him for years and years. And I'm still recovering from everything he did to me all those years. It seems so inconceivable to me to be facing potentially 40 years to life in prison when my husband was the one that terrorized me.
When she's finished, it's Judge Bowman who has the last word.
I understand, Ms. Harper, that you feel that a 40-year to life sentence is unfair, but you have to understand that your husband got a death sentence. Your husband's never coming back. All right? Unfortunately, the court does not have the ability to fashion a sentence that would bring Mr. Harper back to life. If I could, I would, and that's what certainly the Harper family would like. That's what your kids would like. This shooting, in the opinion of the court and in the opinion of the jurors, was no accident, and you killed him just days after filing for divorce. You are no doubt a danger to society in the opinion of the court, and you are sentenced to 40 years to life in prison for the killing of Jason Harper.
Julie Harper's serving her 40-year sentence in a California correctional facility. She'll be eligible for parole in 2034, and she'll be 61 years old. The Harper children are currently living with Jason's parents. Next, we're in El Paso, Texas, where 29-year-old Myra Lopez is before Judge Bonnie Rangel for a probation status update. 3 years earlier, Lopez, a divorced mother of 5 young children, was charged with 1 count of unauthorized use of a vehicle after she refused to return a car she borrowed from her then-boyfriend. She pled guilty, and Judge Rangel deferred her sentence under the condition that if she completed 5 years of probation without reoffending, she could apply to have those records sealed. During the first 2 years, however, Lopez struggled, violating her probation by repeatedly testing positive for marijuana. Eventually, she made progress when a hair follicle test showed she had been drug-free for 6 months.
Miss Lopez, I'm very proud of you.
Thank you.
Very proud of you. As angry as I've been at you many a time, I am very, extremely proud of you.
Thank you, Your Honor.
But today, 6 weeks later, Lopez has been summoned to court after again testing positive for marijuana. Judge Rangel is not happy.
You gotta go to jail, Ms. Lopez. You know what you're doing is illegal. It's not like this is the first time we've had this conversation.
I understand.
No, you don't understand. You're leaving 5 children blowing out in the wind because you like to smoke pot. Do you think it's okay to do marijuana, Miss Myra, still? After all these years with me?
Can I be completely honest with you, ma'am?
Yes. Yes.
Yes, I do. It helps me. My children are not left unfed. I've had CPS come in for the same reason. I'm not neglecting them. They're well dressed, they're well fed, my house is clean. I'm on top of everything I'm supposed to be. It's just when I get inside my head, I have nobody to talk to about it. So my next coping skill is marijuana or CBD.
Are you ready to get better and stay in jail for a while until we put you in a facility, Miss Lopez? It could be 6 to 9 months.
That's fine with me. I'll do whatever I have to do at this point, because I do want a better life for my children. I don't want the cycle to continue.
Do you have a little bit of money to consult a family lawyer?
The only thing I have is honestly like $100 to my name as we speak right now.
Lopez seems resolved that going to jail is her best shot at getting help. Until...
Your Honor, may I interrupt?
Defense attorney Teresa Caballero, who's in the virtual courtroom waiting for another client's hearing, speaks up.
Your Honor, I would like to take this case pro bono if the client would have my representation.
Miss Lopez, are you open to that? Miss Caballero is one of the best attorneys in El Paso County, and she has got the most generous heart. Thank you.
Yes, thank you.
You're welcome, Miss Lopez. You know, these women are unskilled, and then they have children, and then life falls apart. And if they go to jail, basically the children are going to be orphaned in a lot of cases. So we're going to have to map out a plan that takes into consideration all of these very deep flaws.
Perfect. Okay, I'll reset this for 2 weeks. I'll let you in your magic. And Ms. Caballero, once again, thank you so very much for this.
Thank you, guys.
With her new lawyer's help, Lopez avoided jail time. She's working on getting her GED, and she has a part-time job. She's also been drug-free for 4 months. Next, we head to Inkster, Michigan for a sentencing hearing. 35-year-old Marcus Graham has been charged with a number of misdemeanors, including double parking, driving with expired plates, no proof of insurance, and invalid license. Graham is represented by attorney Samer Jadala.
At this time, Mr. Graham will be pleading to 1 count of no proof of insurance, 1 count of expired plates, 1 count of no operator's license on person, and 1 count of double parking.
Ooh, okay.
Judge Sabrina Johnson quietly goes through the charges, but Graham seems eager to defend himself.
Your Honor, if I may get a second to address the court, if you give me the right.
You can. Hold on just a second. So,
while you're writing,
no,
I just wanted to address the court.
Hold on, I'm not done yet.
Yes, ma'am. Yes, ma'am, I am. But while you're writing, I just want to address the court and tell you.
You're driving my people crazy, Mr. Graham.
Slow down. Listen to what the judge is saying. Just hold on.
Mr. Graham, you ever slow dance with a partner?
No.
Okay, that's why you don't know how to do this. just follow me. I'm leading. Just follow me, and then I'm gonna turn it over to you. You ready? So I'm leading.
Okay.
Just raise your hand. Do you solemnly swear or affirm the testimony you're about to give will be the truth?
Yes.
Great.
Yes.
Did you operate a vehicle in the city of Inkster September 25th, 2021 without a valid license on your person?
Yes.
Did you also have no proof of insurance on that date?
Yes, but I have it now.
I know. And then you also, that vehicle had an expired plate, right?
But I went to Secretary of State and I have the plates now and I have proof of it.
I know you do, or we wouldn't be accepting this plea. And you were also accepting a responsibility for double parking on that day. Is that true?
Yes, ma'am.
Okay. Now, what is it that you just got to tell me?
Okay, it seems like it's a long list of stuff against me. But even though it was, I took the proper steps as a responsible adult to take care of those things. I did get insurance. I did go to Secretary of State and pay the money to renew my tags. And even though I pleaded to these charges, I'm not in some I don't care attitude or it doesn't matter. I work 2 jobs. I live alone. But I'm trying to be responsible. And I just want you to keep that in mind while you pass your sentence down towards me. I'm sorry, I don't know how to slow down. I don't.
Times in life where you just gonna have to trust the process.
Because of his efforts to get his documents updated, Judge Johnson reduces some of Graham's fines, leaving him with a total of $605.
Okay. That's like a month of wages. Will you give me some time to pay it?
I sure will.
Okay, that's all that I asked.
Hold on. Can you take care of it in 90 days?
Yes, ma'am, I can.
Great.
Graham eventually paid all of his fines, and his case is now closed. Next, we're in Battle Creek, Michigan for an enforcement hearing. 32-year-old Derek Wagner is being charged with civil contempt for not paying child support. The complainant, who appears without a lawyer, is 29-year-old Kelly Bridges, the mother of Wagner's 3 children. Wagner, who's currently in custody on an unrelated charge, has previously been held in contempt for failing to appear at a child custody hearing. He owes over $4,700 in arrearages. Today, he appears before Judge Brian Kirkham. He's represented by public defender Kevin Sackrider, who has some questions about his previous contempt sentence.
You bonded out on February 23rd by posting a $100 bond. Are you willing to put that bond amount towards your child support arrearages?
Absolutely.
He needs to pay more than $100.
Ms. Bridges, we're taking testimony from Mr. Wagner, not from you at this time, so please don't interrupt.
Prior to February 16th, were you employed?
No.
Lie.
Ms. Bridges, was I unclear about not speaking or interrupting?
So what, y'all can shake a piece of shit motherfucking hand and say congratulations?
Hey, ma'am, if you go off like that, you can be held in contempt of court and go to jail. Do you want to do that?
Just proceed through the court hearing and shut up.
Ma'am, one more outburst or one more vulgarity and you will be going to jail. You understand?
Good luck.
What, ma'am?
I said good luck. Finish court.
The judge remains patient and moves on, asking the defendant a few questions of his own.
In the last year, how much have you worked?
Altogether, probably about 2.5 months.
And during that time, you obviously didn't pay any child support. Why was that?
I just failed to pay. I failed to pay. I mean, honestly, there's no excuse for it.
The judge is now ready to make his ruling.
The court will find that he has had the present and the ability to pay, that he's failed or refused to pay, and therefore he is in contempt of court. I could sentence you up to 45 days. I'm not going to do that only because it is your first time that you would have any jail time. What I'm going to do is I am going to sentence you to 21 days in jail with credit for 7 days served. Court will end this matter. You're free to go. Have a good day.
Bridges is not pleased with the sentence, and she lets Judge Kirkham know it.
That's bull. You guys shake his hand and tell him congratulations.
Ma'am, the case is done. We don't need to hear anything else from you.
Bye.
Now, hold on, ma'am. The court. Miss Wills, do you have Miss Bridges' phone number? Can you contact her and get her back?
Yes.
Moments later, Bridges is back on the call.
Miss Bridges, I had warned you multiple times about your outbursts and your vulgarity, and apparently that did not have any impact.
You don't want to listen to anything I say. You just want to shake this motherfucker's hand and tell him congratulations. Let's get
Ma'am,
this
the
shit
court
out
is
of
holding you in contempt of court. I'm sentencing you to 3 days. 3 days jail, ma'am. You will be sentenced to 3 days in jail. You will have to appear. If she fails to appear, the court will enter a bench warrant for her arrest at that point.
Bridges did appear and served her 3 days for contempt of court, while Wagner served his 14 days also for contempt. Next, we're at the Liberty County Courthouse in Hinesville, Georgia. Ralph Robinson starts his morning by staying active and doing his daily exercise. His routine includes taking a walk up the courthouse steps, but today's walk would be anything but routine. The elderly Robinson collapses. 15 seconds pass as Robinson lays on the ground. A woman who's standing nearby rushes to his side. She takes a look and then makes her way inside the courthouse for help. Another 15 seconds pass before the woman returns, followed by security officer Gary Eason, who immediately begins to check the man's vitals. Eason, who was just beginning his shift at the courthouse, sees that Robinson is not breathing. He goes to work immediately and begins chest compressions as onlookers begin to gather. Another woman comes from across the street to help as Eason continues the chest compressions. After more than a full minute of compressions, the pair desperately continue to apply life-saving measures to Robinson. The efforts of Gary Eason and the woman on the street are successful as Robinson finally regains consciousness. The first words from Robinson's mouth were, "Thank you." He's then taken to a local hospital by ambulance. During a hospital visit, Robinson thanked Officer Eason one more time. He also told him he received a pacemaker so that Eason would not have to save him again in the future. Next, we go to Centerville, Michigan for a sentencing. 59-year-old Edwin Smith has pled guilty to failing to stop at the scene of an accident, causing personal injury. 8 months earlier, Smith was behind the wheel of his car in a parking lot when he drove into his co-worker, Kimberly Van. Smith fled the scene, while Van sustained several injuries to her back, neck, and legs that required surgery. Smith was soon arrested and charged. Today, he appears along with his attorney, Luke Knopsinger, before Judge Jeffrey Middleton to hear his sentence. Smith could be facing up to 93 days in jail.
Mr. Smith, what would you like to tell me?
I'd just like to apologize to this man for the whole deal. Truly sorry.
Just a minute.
Happened.
Just a minute. I heard a big you.
That obscenity came from the victim, Kimberly Van, who's just off camera in the gallery.
I expect you to be respectful in here. And if I hear it again, you're going to be found in contempt and you're going to go into custody. Do you understand? Do you understand?
Yeah.
All right, go ahead.
I would just like to apologize for all of it. Truly never meant for it to happen.
Ms. Van, if you think you can keep it together, do you want to speak to me? Please come forward.
Van comes forward to make a statement to the court.
Sorry for cussing, but I do not believe that his apology.
Well, what would you like me to know?
I am asking the court to hold him at the max jail time that is possible. He should go to jail and lose everything like I have. I have now been fired because I was unable to return to work after surgery. I still have pain. Please do not be lenient when you go to sentence him today.
Do you believe he ran over you on purpose?
I believe he ran over me on purpose because he was drinking.
If he was drinking, there certainly isn't enough evidence to charge any drinking driving.
I wasn't drinking that day.
According to police, there's no evidence that Smith had consumed any alcohol on the day of the incident.
I do not believe he intentionally ran over you in the parking lot. You want him to go to jail for the maximum amount of time. You want him to lose his job. None of that is going to fix your injuries. I am sorry that you lost your job.
But I wouldn't have lost my job if I wouldn't have gotten hit by a car.
All right, so you want to tell me something else?
Just go ahead.
Judge Middleton moves on to the sentence.
I am going to do a 12-month probation. And he isn't going to use any alcohol or any controlled substance.
So he's not even going to jail for this?
Stop.
I'm just asking a question.
I'm doing the sentencing. Stop. I'm going to order 10 days jail to be served either on weekends or work release. I'm not going to make you lose your job.
10 days.
A frustrated Van heads for the exit.
Go get her. Please come up and have a seat.
Whatever you want.
All right, you want to curse at me a little more? Is there anything else you have to say? All right, you should just go now.
Van exits the courtroom for the second time, but again is unable to hold back her emotion.
All right, come here.
The deputy rushes out to retrieve Van.
I find that you're in contempt of court and you're going to jail for 24 hours. Effective right now. Yes, really. You did this to yourself. You're going to jail for 24 hours for your continuing disrespect. I gave you a chance to just leave and then take her out of here. Yes. All right, I'm sorry. I took it as far as I could take it.
Later that day, Van's attorney filed a motion asking the court to reconsider the contempt order. Van was released, and the request is pending. As for Smith, he was sentenced to 10 days jail plus 2 years of probation.
We head to Warren County, Ohio for the sentencing of Lance Runyon. The 57-year-old pled guilty to attempted aggravated murder. More than 6 months earlier, the husband and father was home alone when he sent an alarming text to his family, causing his brother to call 911. The brother asked police to do a welfare check on Runyon, who, as it happens, previously worked as a corrections officer. The visit's captured by a doorbell camera. There's several deputies outside, including 12-year vet Sarah Vaught.
What do you say? 482, she'll give you the garage code if she wants us to check on him. Here it comes. Here he is, here he is.
Runyon fired once at Deputy Vaught, but somehow she avoids getting hit. Not so for Runyon. who was hit multiple times.
Show us your hands! Show us your hands! Show us your hands!
I'm good, I think.
The deputies tend to the fallen Runyon. He was taken to a local hospital and survived his injuries. Runyon pled guilty to all charges and claimed he couldn't clearly remember the incident.
For the state of Ohio versus Lance Runyon, we are present for sentencing.
At sentencing, Runyon's looking at a possible maximum of 23 years in prison. But first, the state plays a full recording of the incident, including a brief comment made by Runyon from inside just minutes before he opened fire. That was Runyon, who then waits another 2 minutes before finally opening the door. After this horrifying moment is played for the court, Deputy Vaught comes forward to address the judge and the man who tried to kill her.
I have dealt with hundreds of people in crisis during my 12 years on patrol. And Lance Runyon is the only one that has tried to kill me. But I did not survive unharmed. I was diagnosed with PTSD and went through months of treatment until my symptoms were under control. I am still healing and will carry the effects of this with me for the rest of my life.
Next, Runyon's given a chance to address the court.
I'd like to apologize to the deputy, the other officers. She just... I just don't remember much of it. I'm sorry that it happened. It's not because I'm in trouble, but because for everybody. And I'm just sorry. Sorry to all of you.
Finally, after hearing Runyon's tearful apology, the judge gets the final word before imposing sentence.
Mr. Runyon, you cannot offer an explanation to the court as to why this happened. Obviously, I'm in no position to be able to try to explain it either. You did acknowledge your guilt. You do not have a prior record, so the court does take that into consideration. So the court is going to order you to serve a period of 10 years, a minimum term sentence in prison with a maximum term of 15 years.
In addition to the 10 years for attempted aggravated murder, Runyon's sentenced to a minimum of 7 years for committing the offense with a firearm, for a total of 17 years in a state prison. We go to the Mecklenburg County Courthouse in Charlotte, North Carolina for a first appearance hearing. 26-year-old Tyler Harding has been charged with 31 offenses, including burglary, larceny, hit and run, assault with a deadly weapon, and fleeing or eluding arrest. 2 days earlier, Harding burglarized a home in Charlotte and stole a Jeep. Police tracked the Jeep's GPS signal to a McDonald's drive-thru, but Harding sped off, eventually ditching the Jeep, stealing a truck, and then picking up his older sister, Krista. Together, they sped across the South Carolina border, but doubled back when deputies there tried to stop them. After blowing a tire, Harding stole another car, his third of the day. That's the owner of the car arriving too late to stop him. At this point, Harding continues on without his sister, who was soon apprehended on scene by local police. Harding careened recklessly down side streets and highways, driving on sidewalks and medians, even going the wrong way down one-way streets. Until He crashed head-on into a car stopped at a traffic light. After pulling the victim, who was 7 months pregnant, out of her car, Harding took off on foot and stole yet another vehicle. But 24 minutes later, as he tried to speed through an intersection, he collided with a pickup truck, finally ending an ordeal that lasted nearly 3 hours. The driver of the pickup was unharmed, and amazingly, police reported no serious injuries from the entire chase, including the pregnant driver, who was taken to the hospital with injuries to her nose and arm, but otherwise she and her baby were okay. Harding was treated for minor injuries and then booked on 13 felony charges, 8 misdemeanors, and 10 traffic violations. His sister, Krista Harding, was charged with possession of a stolen vehicle. Today in court, the prosecution argues for an increase to Tyler Harding's $115,000 bond, since they say he's a clear danger to the community.
He's driving on the wrong side of the road at excessive speeds, weaving in and out of traffic. He's just demonstrated he doesn't care for anybody's safety in this community. He doesn't have a North Carolina driver's license. We have no knowledge that he is a resident of this state.
Harding recently had moved to the Charlotte area, but had an extensive criminal record in Texas. Judge Donald Curtin takes this into account when considering bond.
His history has a lot regarding theft, as well as fleeing or trying to evade arrest. Obviously, the allegations in this case are no different. If anything, they are aggravated. So as a result, I am going to honor the request from the state in terms of raising the amount of the bond.
After hearing the judge's decision, Harding, who's been raising his hand throughout the hearing, seems like he's heard enough.
Bro, this. Hey, I'm letting him back. Nah, I'll let him finish.
Hold on. One thing you're not gonna do is give me permission to do anything. I already have that, so I don't need your permission.
No,
so you can go. No. You can go ahead and leave. You already upset. Go ahead and leave. Go ahead and leave.
It's important for me to hear this.
Well, it didn't seem that important just a few seconds ago when you said F this and you wanted to leave.
Because you're listening to what this gentleman has said to you, and it's not my place to tell you what happened yet because I haven't spoken to my attorney yet. But that's what actually is a crime to lie.
Thank you.
Judge Curtin wraps up the hearing by increasing Harding's bond amount to $800,000. Harding has failed to post bond and is being held in Mecklenburg County Jail pending trial. His sister, Krista Harding, posted $25,000 bond and has been released pending trial. Next, we're in district court in El Paso, Texas for a virtual settlement hearing. 40-year-old Tony Orozco is facing a litany of charges, including burglary of a habitation, criminal mischief, and possession of a controlled substance. He could be facing as much as 22 and a half years in prison and fines totaling up to $22,000. But as the hearing begins, Orozco, who is currently free on a personal recognizance bond, is nowhere to be found. So his attorney, Daniel Avalar, asks Judge Bonnie Ronhell if they can proceed without him.
May I move the court for a waiver of presence?
Sure, of course.
Avalar's worked out a favorable deal with the prosecutor. If Orozco pleads guilty to felony drug possession, he'll get no further jail time. The state has also agreed to lower his felony burglary charge to misdemeanor trespassing and dismiss the criminal mischief case. Now, the max Orozco could get would be 6 months in jail and fines up to $2,000.
That sounds pretty sweet, Mr. Aguilar. What do you think?
Yeah, I think we're about there, Judge. Yes.
You want another settlement conference in 30 days?
Would you mind?
No, of course. Of course, a settlement conference in 30 more days.
The judge schedules another hearing to finalize the deal. But a few minutes later, Orozco suddenly signs into the hearing.
Okay, Mr. Orozco, your attorney just took care of your case. You're a little bit late. The hearing was at 11 o'clock, sir. It's 11:20. Where were you?
Downloading all this stuff.
I'm sorry?
Downloading the app and doing all this email stuff. Looking for it in the.
Good idea to download it at 10 o'clock so you would be on time, Mr. Orozco? Wouldn't that have been a great idea?
It wasn't on my agenda at 10 o'clock.
Well, it better be your agenda. The next time you're late, you're going to jail, Mr. Orozco. Do you understand? You better make your agenda to show up on time for court.
Well, I am showing up on time for court, not in Zoom.
Mr. Orozco.
On my other court.
Mr. Orozco, it's yes ma'am, no ma'am.
Avalar tries to steer his client into safer waters, but Judge Rangel has already had enough of Orozco's behavior.
You're doing 3 days in jail, Mr. Orozco. 3 days in jail for your disrespect. I don't care where the heck you are. You're going to disrespect me. You're going to respect this system. You're going to jail for 3 days right now. Maybe that'll change your attitude a little bit, Mr. Orozco.
Attitude? I don't have an attitude.
Okay, sir. Think about it in jail. He's going to jail too. He has to turn himself in tomorrow, 8 o'clock in the morning for this disrespect.
But Orozco apparently doesn't have jail on his agenda either.
No, ma'am. Sorry.
Mr. Orozco, I don't think you understood what.
No. I'm just saying I haven't even in my court. I'm sorry. I'm just his wife.
It's 6
days.
days.
She's coming on me like this. No.
6 days in jail. You want to keep talking, Mr. Orozco, to make it longer?
Mr. Orozco, we got you a fantastic deal. I think there should be a certain level of respect right now, okay? With the court. She's not having it right now. I think he's off, Judge.
Wow, he left. I'm telling you, people think they can give me and disrespect me and give me crap because we're on Zoom? No way. No way.
Orozco did not turn himself in the next morning as ordered, so his personal recognizance bond was revoked and a warrant was issued for his arrest. 7 weeks later, at another virtual hearing, Orozco showed up on time, but it appeared that jail still wasn't on his agenda.
Sir, I'm going to ask you to turn yourself in again.
And I'm sorry, I have a job. I have responsibilities out here. Okay. I mean, I know it's easy for you to ask me to do that, but it's not easy for me to do that.
Okay, sir. We'll have to have you arrested, sir.
You know, this bench warrant is for no reason. It's your personal problem that I have to go to jail. Not because of anything. I didn't do anything.
Mr. Orozco, it's not going to go very well for you, sir.
8 months later, Orozco was arrested on a new drug possession charge. After spending a couple of months in jail and not displaying any issues, Judge Rangel released him on a new personal recognizance bond with an order to attend drug treatment. Eventually, both drug charges were dismissed. And after the complainant in Orozco's burglary and criminal mischief cases stopped communicating with the district attorney's office, those charges were also dropped. Next, we're in Detroit, Michigan for a pretrial conference. 26-year-old Micah Bradford has been charged with 3 counts of assault in 2 different cases. She pled not guilty to all 3 counts, posted a $5,000 bond, and was released. Today, she appears before Judge Elenice Bryant to discuss next steps in the case. As the hearing begins, Bradford experiences some technical difficulties.
Judge, it looks like her device is not connecting.
But Judge Bryant is more concerned with another matter.
All right, Miss Stevenson, you spoke to Miss Bradford in the breakout room, and now she's laying in the bed, attending court. That's so unacceptable and so ridiculous. I don't even know what to say. That's so unacceptable and ridiculous. I'm sending her back to the breakout room.
The judge moves on to other cases until the defendant finds a different location. A few minutes later, Judge Bryant recalls Bradford's case. This time, the defendant appears standing at a kitchen counter.
How are we proceeding?
Your Honor, on behalf of Ms. Bradford, we would first offer the court an apology for Ms. Bradford's prior appearance without offering this as an excuse. Just wants the court to know she was not lying in bed. She was on her bed trying to charge her phone. That won't happen again. She'll charge her phone.
She was laying in the bed. I don't care what she was doing in the bed. She was clearly laying in the bed. She could have charged her phone and not be lying in the bed. Second of all, once the court brought to her attention that she was lying in the bed, everybody else that was uninformed enough to come to court in the bed would get up out of the bed when the judge says, you're in the bed.
Bradford does not seem to appreciate the judge's comments.
Continue, Ms. Stevenson, but she was laying in the bed. Laying in the bed. She was laying down in a bed. I said, ma'am, anything you say probably is not going to work out good for you. Ms. Stevenson?
Thank you, Your Honor. So, Ms. Bradford, ma'am, if you could just listen attentively to what the court's saying. On behalf of Ms. Bradford, we would move for dismissal for the complainant's failure to appear.
Ms. Ritter?
Yes, Judge. So the people respectfully request the court to adjourn both cases for pretrial conference to give the complainant witnesses one more opportunity to appear.
The court is going to deny defense counsel's motion for dismissal. The court will set the pretrial conference for Wednesday, June 14th.
Before the hearing ends, the judge has a few more words for Bradford.
Ms. Bradford is having extreme difficulty in attending court properly. She currently has her hands on her hips, and I'm having a difficult time dealing with Ms. Bradford via Zoom. And then in response to me addressing the hands on the hips, then she folded her arms in front of her. If you are going to come on Zoom, you're not going to attend court inappropriately. It's just not going to happen.
With that, Judge Bryant adjourns the case. If Bradford is found guilty on both charges, she could be sentenced to at least 90 days in jail. Next, we take you inside Gwinnett County Superior Court in Lawrenceville, Georgia, for a sentencing. The defendant is 15-year-old Reginald Lofton. He's been convicted of felony murder, armed robbery, and aggravated assault. 9 months earlier, Lofton, along with 21-year-old Jermaine Young, ordered pizza at their apartment complex. When delivery driver Shane Varnador showed up with their food, they robbed and shot him, leaving the 28-year-old to die in the parking lot while they went upstairs to eat. When police investigated, they learned that Lofton's phone was used to place the food order. After searching the apartment, they discovered hidden pizza boxes, as well as the gun used in the crime. While it was unclear to investigators who pulled the trigger, Young and Lofton were both arrested. Lofton, who was 14 at the time, was charged as an adult. Both pled not guilty, and their cases went to trial. After hearing all the evidence in Lofton's case, the jury returned with a verdict.
In the first count of malicious murder, not guilty. We, the jury, found the defendant in the second count, felony murder, guilty.
Even though he was charged and tried as an adult, Lofton's ineligible for the death penalty since he's a minor. Now at sentencing, Lofton appears before Judge Randy Rich to hear his punishment. But before the judge imposes sentence, Lofton's sister, Portia Porter, pleads with the court for mercy.
My brother do deserve a second chance at life. Instead of throwing him under the jail cell, help him. Counseling.
When she's finished, the young defendant briefly addresses Shane's family, including his mother, who's sitting in the gallery.
I do want to say that I'm sorry for your loss, but I did not kill you or something like that. And I wasn't a shooter. That's it, Judge.
The judge sentences Lofton to life in prison.
But because he's a minor, in the state of Georgia, Lofton's eligible for parole after 30 years. Before he's removed from the court, the judge has a final few thoughts for the defendant regarding the length of his sentence.
I wish I could give you more time than I can because I think you're a cold-blooded killer. I hope you never get out of jail.
Lofton was sentenced to an adult prison for life, but he'll be eligible for parole when he's 45 years old. As for Young, he was found guilty on all charges, including malice murder and armed robbery. He was sentenced to life in prison with no chance of parole for the murder, plus another 20 years for the aggravated assault. Next, we're in Ionia, Michigan for a sentencing. 61-year-old Cheryl D. Morgan has pled no contest to driving under the influence and assaulting or resisting a police officer. 3 months earlier, Morgan, who already had 3 prior DUI convictions, was pulled over and asked to take a field sobriety test. But police say Morgan was uncooperative and allegedly threatened officers, even kicking one in the shin. She was arrested. Later, a blood test revealed that her BAC was 0.18, more than 2 times the legal limit. Morgan was also initially charged with driving with a suspended license and having an open container of alcohol in her vehicle, but those charges were dropped as part of her plea deal. Today, she appears before Judge Ronald Schaefer to hear her sentence. The state, represented by Kyle Butler, is asking for a sentence of 150 days in jail plus probation. But first, Judge Schaefer checks in with defense attorney Karen Constantine, who argues that her client cannot serve jail time because of medical issues, including respiratory problems and nerve damage in her back that requires surgery.
All right, Ms. Constantine, allocution on behalf of your client.
Yes, Your Honor. Miss Morgan has so many health problems. My biggest issue is CPAP. If you don't use a CPAP, then you stop breathing. The jail does not allow that. I've already called them and asked them. So I am asking this court to place her on a tether for whatever, 90 days, 6 months, but she can't walk. She has nerve problems. That's why I'm asking the court to put her on tether.
Before making a ruling, Judge Schaefer wants to hear from the defendant.
Then, Ms. Morgan, did you have anything that you want to state to the court before a sentence is imposed?
I'm sorry for everything, but I don't want jail because I have to go set up surgery for my back or I won't be walking. And he just put plates in my neck.
You have 3 priors. Your bodily alcohol content was 0.18. I do not have faith in you. And I'm not unsympathetic to your physical conditions. Your physical conditions did not prevent you from fighting with the officers, pulling your arms away, making a fist, telling them that I'm going to kill you. Your physical condition didn't prevent you from kicking an officer in the shin, right? It's hard to buy when I hear today, Judge, boy, I just can't do any of that because of my physical condition, but I can kick a police officer. They don't go together, do they? But the fact of the matter is, here we are, 4th offense today. You're not interested in addressing your alcohol problem. You don't think that you have an alcohol problem. How would this court look when a 4th offense drunk driver gets no jail time, and then 6 months from now, and you kill somebody? Well, you can roll your eyes, but it happens every day. Ms. Morgan, I don't need to hear anything from you. You've already had your opportunity to speak.
And with that, the judge exceeds the state's recommendation, sentences Morgan to 13 months to 5 years in prison, plus $1,800 in fines and court costs.
File anything else from either side?
Your Honor, could you please discuss what we're supposed to do with the CPAP?
It's not the bailiwick of the court to instruct the jail for the Department of Corrections on how to manage the health conditions of their inmates.
Morgan will be eligible for parole after she serves 13 months.
Next, we head to Wyandotte, Michigan for an arraignment. 56-year-old Arthur Haley's been charged with possession of a controlled substance, assault, resisting arrest, and obstructing police, as well as a traffic violation. A day earlier, Haley was pulled over for failing to use a turn signal, but he fled the scene and headed home. When police caught up with him later that night, they found him in possession of a controlled substance. He was arrested and charged. Today, he appears before Judge Elizabeth DeSanto to hear if he'll be granted bond. The defense attorney is John Goldpaul, who enters a plea on his client's behalf.
We'd ask that the plea of not guilty be entered on his behalf.
Yes, to bond counsel.
Your Honor, Mr. Haley is 56 years old. He does have a prior criminal record. He did have a felony drug case back in the 90s. At no time has he ever failed to appear. He's not on probation or parole at this time. We'd ask for a personal bond in this particular matter. Mr. Haley knows the consequences of not appearing, and I'm sure that he will be appearing in court.
When was the last time you were employed, sir?
2002, 2004.
And so how have you been supporting yourself since then for the last 17 to 19 years?
Bingo.
I'm sorry?
Bingo. I'm a
Bingo?
professional bingo player. Yes, ma'am. I play bingo.
Okay, well, that's the first. I have not heard of a professional bingo player. How much does one make being a professional bingo player?
Oh, it varies. If I just chase big jackpots and progressive games all over the state.
So for the last 17 to 19 years, you've been strictly working as a professional bingo player.
Pretty much.
The judge wraps up the bingo conversation and inquires further about Haley's criminal history.
So tell me about your felony assault charge out of Detroit in 2012.
Me? I don't really recall that.
All right, what about 2015 out of Detroit, felony assault?
Ma'am, I don't know anything about it.
You were never charged with that?
Your Honor, I recently was acquitted of a charge. I cannot remember the exact year. I was acquitted of all charges. And I have not been in prison in anybody's jail since 1994.
Okay. Well, in 2020, there is a warrant, 4 counts of felony firearm, dangerous weapon, carry and conceal. Do you know anything about that?
That is not me. 2020, oh no.
Haley may have foggy memories about his earlier legal problems, but it turns out he's correct about the gun charges from 2020. Records show that Arthur Haley is 22 years younger than this one. In any case, Judge DeSanto decides to move on to Haley's most recent charges.
All right, well, here's what I'm going to do. I'm going to indicate a $5,000 10% bond, not to possess or consume any alcohol or drug unless prescribed. If you're tested today, what would be detected in your system?
I just a glass of wine.
A glass of wine? Okay.
Last night, yeah, that's about it.
Okay. All right, so 5,000 10% bond. We'll see you back next week.
Haley posted bond, and his case is pending. We're in Hillsboro, Ohio for a pretrial hearing. 27-year-old Stevie Dawn Coulter has been charged with 5th-degree harassment, a felony. 5 months earlier, officers approached Coulter after they saw her stumbling while walking in public. She admitted that she was under the influence of methamphetamine, and when she tried to leave, she was arrested for obstructing justice and resisting arrest, both misdemeanors. Then, while in custody, she spit at and grabbed the hair of deputies, picking up the felony harassment charge. She was released on her own recognizance, but was subject to pretrial supervision, including drug testing. Today, Coulter's in court to enter a guilty plea that would include court-ordered drug counseling and potentially no jail time. She's represented by defense attorney Dennis Kerr. The judge is Rocky Koss.
David Hyatt versus Stevie Don Coulter. Are you Stevie Don Coulter? Yes. Pardon me? Yes, sir.
Right away, there seems to be something slightly off with the defendant.
Are you all right, Miss Coulter? I can't hear you. You have a really bad headache? Anything else wrong with you? Well, we'll go ahead and have this pre-trial, but a couple things I want to talk about. I have a report from the probation department that she's been testing positive for gabapentin, marijuana, methamphetamine, amphetamine.
I just have a question. Does it even test for gabapentin on a 10-panel drug test?
What's that now?
Does it test for gabapentin on a 10-panel drug test?
Okay.
I mean, I'm a very intelligent person, and I know a lot, and I just look stuff up all the time.
Coulter then brings up what she believes is a discrepancy in her arrest report.
And in this statement from the police, from this one, it says, then I identified female Stevie Coulter, not Stevie Coulter identified herself. So he arrested me based off of...
Okay, well, that's not what we're here about here today, Miss Coulter. It's clear that you're not in a situation...
But they lied also, though, Judge.
You don't interrupt me, Miss Coulter.
Hair and everything. I was denied access to the video.
Miss Coulter, be quiet.
Wrong.
Be quiet. Don't speak.
Because they lied.
Be quiet, I said. I'm not lying. I said be quiet. You understand me?
It lied.
By now, the judge seems to have had enough.
All right, I'm holding you in contempt, and you're going to be sentenced to jail for 10 days. Miss Coulter, you're disrupting this proceeding.
I promise you, I'm not trying to be like that.
Yeah,
But it's black and right. It's right there.
All right.
I highlighted it. Then I identified within the first 3 lines.
I don't even know what you're talking about because it has nothing to do with what we're here for today.
The police officer that arrested me, it was wrongful arrest, and then I had 5 cops on me.
All right, you have an attorney.
I had 5 cops on me.
Miss Coulter, you have an attorney.
I wasn't even I didn't even touch that girl. It was my only form of defense.
Take her into custody, put a cuff on her. Put you back.
I don't care if it's It's wrong. You're like the big threat. I want a new trial.
As she's taken away, Coulter delivers a parting shot.
I hate every person in this.
After serving 10 days in jail for contempt, Coulter was ordered to report to probation for failing multiple drug tests. But when she failed to report, a warrant was issued and she was arrested again. And then, 6 days later, according to court records, Coulter was ordered to undergo 6 months of psychiatric treatment in order to evaluate her competency for trial. Her case is pending.